Hello, good evening. Welcome to the Supreme Court Observer. This is Leena Raghunath, and today we have Dr. Mahendra Pal Singh with us. Dr. Singh is a distinguished jurist and scholar in constitutional law, administrative law, and comparative law. He holds the title of Professor Emeritus at the University of Delhi. He read for his LLM under the leading constitutional expert V.N. Shukla, and today he's widely known for authoring the revised edition of V.N. Shukla's Constitution of India. It's one of the most authoritative and respected academic book. In his prolific career, Dr. Singh has authored more than 100 papers in both national and international legal journals, as well as edited works. Additionally, he has written 10 books, among which the internationally appreciated book on German administrative law from a common law perspective is one. Welcome to this conversation, Dr. Singh. Taking to what we are going to talk about, it's this earlier this week, we had the Supreme Court judgment coming out in the abrogation of Article 370. Chief Justice Dr. Chandrachud and his four brother judges upheld the Union government's action to abrogate Article 370, which granted special status to the Jammu and Kashmir. The court, among other things, refused to comment on the constitutionality of the reorganization of Jammu and Kashmir into two union territories, Jammu and Kashmir and Ladakh. Of the many people who have commented once the judgment has come out, we have heard Falias Nariman say that this is an incorrect appreciation of the Constitution that he didn't expect the court to do. So with this, we open up into this conversation and some of the important questions that we think were raised with this judgment. So Dr. Singh, what do you think about the Supreme Court brushing away with the recommendation requirement in Article 373? According to your opinion, do you think the president have a plenary power to abrogate special status, considering the Constituent Assembly of J&K ceased to exist in 1957? So the whole wording of the recommendation shall be necessary, the court ruled that is not binding on the president. So how do you see the current position on this?
Yeah, of course, so far as the president is concerned, it is his discretion which he has to exercise. But once he has exercised in one way, then that is the final verdict from the side of the President of India. Therefore, that is binding. I am not quite sure whether Fali Nariman is correct in his view that only 368 had to be approached for this purpose. I think the unanimous decision of the Supreme Court is the right one.
Coming to the legal strategy that we see here employed to do this, the abrogation, the whole of Constitution applicable to J&K under 371D, the concurrence of the government required becomes the concurrence of the parliament because the state was in president's rule at that point. And we can basically see that a representative of the union in the state was asking for the union's concurrence, which is the governor here. Would you consider this strategy malified on the part of the Constitution, or would you agree that this was kind of a fraud on the Constitution argument here?
I don't think there was any fraud on the Constitution. Of course, one can look at things differently because there are possibilities of different interpretations of the Constitution. But the line which the Supreme Court has adopted in this case, I think that is the right one.
Throughout the arguments also, we have understood that this whole idea of sovereignty, having a separate sovereignty argument doesn't stand. How do you see the sovereignty question?
Yes, sovereignty has to be one for the country. And therefore, so far as the sovereignty is concerned, I think the Union of India has to establish its sovereignty over the whole of the territory of India. And to that extent, not only territory of India, but also in the international world, so far as sovereignty is concerned. Of course, the issue of sovereignty is quite complicated, but even then, going by this case, I think the exercise by the President of India, is the right one.
Do you think that Article 370 could have been amended under Article 368, and why didn't the union take this route of going the 368 way? Is it because in the Rajya Sabha that they didn't have an absolute majority, that they didn't opt for this route of amending 370?
So far as 368 is concerned, that could not actually change the nature of 370. 370 had to be changed in its own terms, and it is what the President of India has done.
This question of 370, I think, equally is a question in the constitutional sphere of things, but it's a question that's largely mired in the political reality of the times too. So overturning 370 over the times was thought of as an impossible move, but today it's done and dusted. And we could debate the political route that was taken to do this, but the constitutional route that was adopted has been sanctioned by the Supreme Court of India. And you are also of the view that, completely opposite to what Mr. Nariman is saying, you are of the view that this route holds strength, that this route stands, right?
That is what I feel. Yes. I am of the clear opinion on this point. Yes. The Supreme Court has done the right thing.
Right.
So there can be always different views of different persons, but I think the Supreme Court has done the right thing in the circumstances. Yes.
Right. You have read the judgment in detail. I just wanted to know from your standpoint, what is the reasoning of the court that has been most compelling to you in this decision?
That sovereignty has to be won for the country, and therefore holding two constitutions within the same country would be a difficult situation, and therefore the Supreme Court has done the right thing by holding that Article 370, the way it stands now, is the correct position so far as India is concerned.
The Supreme Court seemed to have placed a very heavy reliance on how the Solicitor General Tushar Mehta made an oral statement that statehood would be restored in a future date to Jammu and Kashmir, and didn't go into this whole question of the state being reduced to 2 union territories because based on that promise. So what do you think about this changing of the statehood and how it was done?
Yeah, so far as statehood is concerned, of course, states can also be in the exercise of the union power, can be abolished. Politically, it may not be appropriate, but we have seen that now we have created so many states, while earlier we started with only few states, and therefore creation of new state is not a problem. We can keep them as union territories. We can also make them as states, including the other part of the, apart from Jammu and Kashmir. So far as Leh is concerned, that can also be created as a separate state. It is possible. I am not saying that it is always convenient to do that, but it is possible. And since they are demanding now, it is also possible to create two states rather than one state of Jammu and Kashmir as it was before.
Also, looking at the asymmetric federalism that we have in this country, do you think that the federal scheme of things has been violated by the judgment or has been forever altered by this judgment?
The judgments are actually in some ways individual, and so far as Jammu and Kashmir is concerned, it was a unique provision under the constitution, which doesn't apply so far as other states are concerned, and therefore a kind of new approach had to be adopted for the purpose of bringing them in line with the rest of the constitution.
What does this mean for various movement across India, where there are special provisions and we have made special accommodations to states? and and they have separate powers and separate protections under the constitution. But now it seems that all these movements that we have been able to keep at abeyance because of the guarantees that we guaranteed under them in the constitution can be taken away by a very centralized government. What does this mean for movements across India? Do you think that every state would be looking at this in a very anxious way, this judgment?
No, but going by Article 1, Clause 1, uh, India, that is Bharat, is a union of states. By going by that article, which is, I think, is a fundamental article of the Constitution, uh, it would be considered to be inviolable article so far as clause 1 of article 1 is concerned. And therefore, states have to remain there. The only question is that whether some of these states can be merged and all that, and that procedure is provided in Articles 3 and 4 of the Constitution. And so long as that procedure is followed in its word and spirit, then of course, the action of the Union of India or of the President of India is the right one, my opinion.
Zooming a bit out from here to
Yeah.
ask, what about the basic structure? Do you
Yeah.
think it is still relevant 50 years after the Keshwananda Bharati judgment came out? Do we still have to look at that basic structure in constitutional litigation today?
My colleague and mentor, Dr. Conrad, actually started the idea of basic structure in India by giving a lecture in 1965 at Benares University. And that lecture actually became a foundation for argument in one of our cases, the last case which Subba Rao decided, Golaknath case. And in Golaknath, actually, though not so openly, but definitely these arguments were observed. And though, of course, Golaknath was not decided entirely on the idea of basic structure. The basic structure was finally established only in that sannyasi case.
Keshwananda. Yes.
Keshwananda Bharati case, yes.
Going a bit to the emergency provisions here,
Yes.
what can and what can't the union do when it is under president's rule? We have been talking about what Gautam Bhatia has written about two kinds of irreversible actions. One, a
Yeah.
permanent action like damming the river by the union government, and one, a
Yes.
constitutional action. And the union can take the physically irreversible action, but it mustn't do
Yeah.
anything to disturb the constitutional arrangement between the union and states. What are
Yeah.
your thoughts on that?
Once a state is created, then it is affected by Article 246 of the Constitution. Accordingly, the states have the certain powers under the Constitution to make laws on concurrent list as well as on the state list. And definitely the union law on concurrent list will prevail, but on a state list, definitely so far as state laws are concerned, they will prevail. And this is how a balance is drawn between the center and the state relationship.
There is also this expansive reading of president's power under Article 360, 356 that we think gives an unfettered straight control on by the union. Is that a fear that arises from this judgment, that there are unilateral powers vested in the head of a state to do to state sovereignty and autonomy? What does that mean? Is there a very union-friendly centralistic view here that comes across through this judgment?
355 actually makes or empowers central government or the union government to ensure that the states are protected against any kind of venture by which they can be destroyed. And therefore, the union government can come for the protection of the state. And the steps that can be taken are already provided in 255, but then 356 is very specific in this regard as to what the union can do. That is, temporarily it can take over the state and run it, but not forever. You cannot destroy the states under Article 356. Only you can control them for some time. And that is what it says. And that is for the protection of the states themselves, because 355 very clearly says so.
This when the constitution was framed, this concept of federalism and Ambedkar's idea of empowering the states to have their own say in things, how that came into place, a bit of guidance to us how to historically place this judgment, and also, how this judgment would change things for the future for us.
Means there is no doubt. I have read some of the dissertations even from Kashmiri people, that there is no doubt that certain matters were uncertain so far as Jammu and Kashmir was concerned. But that uncertainty was removed in course of time. And finally, I think the government has taken advantage of that change of minds, that now there is a time that we should bring in the state of Jammu and Kashmir in line with the rest of the states. It should not look as if it is a country of two states at the same time. Jammu and Kashmir on the one side and the rest of India on the other side. This could not be envisaged forever.
I wanted to maybe I should have asked this question in the start. Did this judgment surprise you, or this was something that was expected and something that you are looking forward to?
It's very difficult to say because you you never know how the judges perceive a particular situation. But expectation was that the Supreme Court will not create fresh problems for the Union of India. And by endorsing its decision, it has actually solved, or in a way, protected Union of India from the troubles which could have arisen if the judgment was any different. Yes.
In an earlier conversation that we have had between us, you have said that this constitution has never come in the way of running this country, that Nehru could have had a nation building exercise under it, Indira could exercise an emergency power under it. Today's union can run it the way that it wants, the union government. I just wanted to bring that up while we close this conversation. Do you have anything to add to that comment of yours?
Yes, we have to ensure that the Constitution functions in terms of course, the ideal constitutions in the rest of the world are functioning. But there may be special situations in each country. For example, the kind of problems in respect of the tribals and the backward classes we had in this country. Not every country did have that kind of problem. And therefore, there are certain things which had to be peculiar to the Constitution of India. And that is how it became so lengthy also. It continues to remain to be the lengthiest constitution in the world, in spite of the fact that many of the constitutions have tried to compare with the Constitution of India, but they remain far behind it. So the length, of course, was relevant so far as India is concerned, and it might be creating some problems sometimes, but I think by and large it has functioned well so far.
Thank you. With that note, let me end this conversation, and thank you so much for joining us and enlightening us with your comments.
Thank you so much for inviting me, though I am now in a village situation where I don't read much law. So thank you so much.
Thank you, sir.
Okay.
Thank you very
Bye
much.
bye. Bye bye.